Hi, this is Mark Wahlstrom, and welcome to another edition of Speaking of Settlements, a featured broadcast on the Legal Broadcast Network. Well, today we're going to do just a quick update and really more of a preview of an in-depth series we're going to be doing over the month of August. And it's going to be on the issue of what I would call increasing regulation and scrutiny of the business practices of insurance and annuity agents, and the impact that that has on structured settlement agents, brokers, and settlement planners. The reason that, one of the things that really kind of brought this to my attention is, as some of you may or may not know, I do quite a bit of work in the multi-claimant and mass tort area. And one of the things, it's a very competitive market, as you might imagine. There's a lot of money, a lot of attorneys, a lot of claimants. And one of the things that a lot of firms are doing to essentially give themselves a competitive advantage is I've seen a trend toward offering free trust services, or free qualified settlement funds, or free or even reduced administrative services for multi-claimant cases or the management of a qualified settlement fund. And it was actually brought up to me by an attorney that we were talking to, because we obviously don't do that. We try to certainly price our products and services fairly, but we don't control the pricing of our trust product. As far as the legal services and the drafting, we're not involved in that transaction or the cost or the transfer of payment. And on the administrative side, our administrative services, we try to, once again, they're clearly laid out in the trust, they're billed, and there's no way to discount them or rebate them or provide a volume incentive. However, many firms that we've been running into have begun to offer these free services. And even more troublesome, I've found, in addition to these free services, is that you're beginning to see it now in the lien resolution area, where people will provide discounted services. And there's a whole body of regulatory and administrative law, particularly in the Medicare, Medicaid, and healthcare area, that very tightly and strictly controls, what is a rebate. There are federal penalties and state penalties in that area. So we've begun looking and examining some of the rules that are out there and determining, is this practice, borderline in the area of rebating, or does it run afoul of any particular state or federal statutes or bar association ethical opinions. Now, the first rule, and kind of one of the things we've broached on before, is the New York State appellate decision that came up in April of this year of a 2011 regulation that was supposed to go in, called Regulation 194. And that requires all agents and brokers to disclose to buyers their compensation and commissions at the time of sale and on renewal of insurance products. It's property, casualty, life, and annuity. Now, this may seem like an innocuous thing, but I mean, it's really the first bill of its kind. Many of the state and federal associations, NAFA and others among them, fought it aggressively in court and lost because people, they viewed it more of an administrative or bookkeeping problem. But a lot of times, how much insurance companies and insurance agents make on a product, it has never been disclosed. People don't know what people are making. They don't know what the compensation is. And not in all cases, certainly, but in a healthy minority of cases, you have people selling products where they're getting tremendous compensation. If the client knew how much the agent was making, they might understand why the agent is pushing a particular product so aggressively. The other bill that we want to discuss, it came out about 5-6 years ago. It was called California Senate Bill 620. And in that bill, and this is very interesting in California, California nominally allows rebating. It repealed its anti-rebating laws, many, many years ago, almost 2 decades ago now. But there's a provision that was put in about 6-7 years ago that says it prohibits sharing commissions or any compensation, both monetary and non-monetary, with a lawyer. This includes a bonus, a gift, a prize, award, a finder's, a fee, monetary and non-monetary compensation. And one of the questions I actually had raised to me by somebody on a California case where we were looking at a multi-claimant case was if this other firm that we were competing with, that their offer of free services that would obviously cost money, for which there would professional services that they were not billing if that didn't run afoul of this state regulation in California that prohibits it. So something we're going to be talking about, something to discuss. It'll be a month-long series. We look to have several attorneys in, maybe some state bar associations to discuss this. But it's a definite trend in the settlement and annuity profession is increased scrutiny, increased regulation on commissions, increased regulations and scrutiny of professional relationships and transactions. On the health insurance side, it's already, particularly in Medicare and Medicaid and doctors' practices and sharing of information, the rules are onerous. And I mean, you really have to have an attorney help you set up anything in that area now to avoid running afoul of these rules. And I think we may be headed in that direction in the life and annuity side. So it's something we need to prepare for. I think it's healthy within reason. You know, we don't want to have an undue burden placed on agents, you know, for a problem that doesn't exist. But in many of these instances, I think from a professional practices standpoint, the structured settlement industry in particular needs to take a hard look at this offering of quote-unquote free services in exchange for the ability to write annuities. It may not be illegal, it may not run afoul of the law yet, but is it appropriate? Is it the way we really want to market our services? And what does it say to the law firms about the quality of those services if we can simply give them away in exchange for annuity commissions? My name is Mark Wahlstrom. I hope you join me for this month-long series right here on the Settlement Channel. I'll see you next week.